The state to convey her objection to the live broadcast of her evidence, be it visual or audio. Up to this point, my lord, the proceedings have been carried live, both audio-visual, except in certain instances where the state would request that only the sound recording of the witness evidence be made. However, the witness has requested that, as I've just intimated, my lord, that the proceedings should not be broadcast live.
Yes.
And the basis of the objection are the following, my lord.
Yes.
Firstly, her personal safety. The witness is a well-known personality. She has to perform in public from time to time. And if these proceedings, my lord, are carried live, there's a possibility that the public might form perception regarding her evidence. And when she then performs publicly, her life might then be endangered. So the first reason, my lord, is for personal safety. The second ground, my lord, is that if the proceedings are carried live, that will put pressure on her. It will make her uncomfortable. She's under no circumstances, my lord, prepared to give evidence if the proceedings are carried live. There's, however, this important aspect, my lord, this important rider. The witness has got no objection if the journalists sit in court and report on her testimony. And just to elaborate on the fact that the live proceedings will bring a measure of discomfort on her part, this ground, my lord, is based on the fact that the live transmission of the proceedings will hinder her when she gives her testimony, in the sense that as has been the position with other witnesses, her evidence is compared to those of other witnesses, is subjected to intense scrutiny, is criticized,
Yes.
And in certain instances, even in the social media, the evidence is subjected to scorn and ridicule. And the witness has indicated that this will naturally come to her attention.
Yes.
And it will unsettle and hinder her to continue with her testimony. My Lord, we therefore submit that it is in the interest of justice that the witness be allowed to give testimony, and she's prepared, my Lord, to, and she is here, she is prepared to give evidence, but subject to the rider that I've indicated that her evidence is not carried live. My Lord, the inception of the proceedings, we have referred to the locus classicus of the NDPP versus Media 24 Limited and others, and HC Van Breda versus Media 24 Limited and others. It's a decision of the Supreme Court of Appeal.
Do you have those judgments?
Yes, 2014 Volume 1, South African Law Reports. And in that case, my Lord, the SCA has laid down certain guidelines when the question arises.
And you say the citation of the case, the name of the case?
It's I'll give the
and you didn't give me the
citation. It's NDPP versus Media 24 Limited and others, and HC Van Breda versus Media 24 Limited and others.
Can you repeat the second one?
It's HC Van Breda. It's NDPP versus Media 24 Limited and others, and HC Van Breda versus Media 24 Limited and others.
Yes.
And the reference is 425/2017. And as I indicated, is the judgment of the Supreme Court of Appeal.
And with the NDPP one is 2014 in brackets 1 SA page?
Page 589.
Yes.
The judgment was delivered on the 21st of June 2017.
21st of
June 2017.
Yes.
And the court referred to the well-known case of State versus Oscar Pistorius, 2014, Volume 1, SACR, page 589. The passage that we want to refer to at paragraph 59, the court held as follows, and we quote, "When there is a debate about whether a given court proceeding should be broadcast, a court is vested with the power to limit the nature and scope of the broadcast where necessary to ensure the fairness of the proceedings before it. The power of the court to do so is an inherent one flowing from the provisions of Section 173 of the Constitution and must be exercised in the interest of justice.
Yes.
And the court went further to point out that in making the decision, the judge may consider the following factors: whether there is a reasonable likelihood that such coverage would, firstly, interfere with the right of the parties to a fair trial; secondly, unduly detract from the solemnity, decorum, and dignity of the court; and at paragraph 72, which is the high watermark argument of the state, the court held the following, and we quote: "When a witness objects to coverage of his or her testimony, such witness should be required to assert such objection before the trial judge," which we are doing currently, "specifying the grounds therefore and the effects he or she asserts such coverage would have upon his or her testimony." This is, my lord, what we have just done. This approach entails a witness by witness determination and recognizes as well that a distinction may have to be drawn between expert, professional witnesses such as police officers and lay witnesses. And this witness will fall in the latter category. Such an individualized inquiry is more finely attuned to reconciling the competing rights at play than is a blanket ban on the presence of cameras from the whole proceedings when only one participant objects. And it says, under this approach, cameras are permitted to film or televise all non-objecting witnesses. And the court went further on at paragraph 73 to hold that if the judge determines that the witness has a valid objection to cameras, alternatives to regular photographic or television coverage could be explored that might assuage the witness fears.
Can you repeat that?
If the judge determines that the witness has a valid objection, so in other words, the court will have to determine whether the objection that we have brought to the attention of the court is valid, and if it's valid, the court can then make alternative arrangements that would address the fears of the witness. As indicated, my lord, the witness has got absolutely no objection if the journalists remain in court, in the public gallery, report on her evidence. The public would still be informed. Of the public will be informed of her evidence. This is as far as we can take this point, my lord. I don't know if there's any other aspect that the court would like to hear us on.
Just for you to put in summary what the witness request for, as I test with through you my understanding. My understanding is that this is a witness that is vital for purposes of these proceedings, and it is a witness that is coming unlike other witnesses who may come here by virtue of the nature of their job, like people who do forensics, people who deal with crime scenes and then formulate whatever is necessary, be it sketches or whatever. This is a witness who is to give an account of what took place on the day of the incident, and she comes as a lay person.
Indeed, my lord.
That's number one. Number two, you are saying that this witness is not objecting to the presence of journalists in the courtroom. In other words, she's still open to the feature of an open court.
Indeed, my lord.
Just as in the same way as any other court and as any other case, which is not this one, is proceeding all over the country today as we speak.
Precisely, my lord, without the glare of the cameras.
Yeah. And what she requests is that the cameras should not beam into her space as she testifies and transmit out into whatever coverage all that she will be doing and saying as she testifies.
Indeed, my lord, and she's indicated that she's got no objection if she walks in the corridor or in the street and you know, her photo is taken. She doesn't have a problem with that. It's only, my lord, as soon as she steps in the witness stand, she requests that she be afforded that privacy, my lord.
Yeah. And then the aspect of her face being broadcast as she testifies, that's the part that I find difficult to understand, in the sense that you are saying at the same time she's a public figure.
Indeed, my lord, she is a public figure, but she's coming to...
Meaning that her face is already out there.
Yes. No, it's not about the fact that her face may not be shown. As I've indicated, she doesn't have a problem if she walks in the corridor or in the street and a photo of her is taken, but she's requesting that as soon as she steps in the witness box and begins to testify, that there should be no cameras or no live recording of her evidence.
So she is saying whatever goes along with her testimony, her language, choice of words, demeanor, and everything should still be open or available for purposes of the open court, but be limited, not to go beyond the courtroom as she testifies, so that it will only be there for viewing by those who are available inside the courtroom?
No, she's indicated that she's got no objection if they generally sit in the...
That's what I'm saying.
Yes, in the gallery, and they just report in the normal way, like any other case, my lord, that she's got no problems with, my lord.
And then you raised issues of decorum and the stature of the proceedings, what we may loosely call the dignity of the court.
Indeed, my lord.
How can that be affected by showing the witness through a live feed?
My lord, as we've indicated, that because of the nature of her status, there's likely to be intense interest in her as well as her evidence. In fact, there is already intense interest, my lord. And, my lord, that elevated interest will, as we've indicated, dissuade her from giving her evidence frankly and openly.
And then regarding what we will term the interest of justice,
yes,
you are saying that that will be that may be affected by her preoccupation with the fact that she is being beamed broadly beyond the periphery of this courtroom as she testifies.
Indeed, my lord. In fact, her standpoint is if the decision, if she has to testify in an open court where there's live broadcasts of her evidence, she might have to reconsider whether she's still prepared to come and give evidence. And that, my lord, will affect the...
It sounds like it's twisting the arm.
Yes.
Isn't it?
Well, that is what came up in the discussion with her, my lord. That's her standpoint, my lord.
I think I've heard you. Oh, by the way, you referred me to as for NDPP case. I think I've read that one. The second case you quoted.
In that first case, the NDPP case, they referred to this second one.
Okay.
Of Oscar Pistorius.
Oh, okay. No. I'm not referring to the Oscar Pistorius one. I think the H.C. Van Breda. Oscar Pistorius I have read, but H.C. Van Breda.
Oh, okay. Versus Media 24.
Yes. What is the relevance of that case? The relevance of that case?
As I've just indicated, the case was quoted in the... in fact, the cases were consolidated.
Yes.
And the passages that I've referred to emanate from the ruling that was made during judgment of those matters.
Okay.
Has it got basis?
As the court pleases, my lord. My lord, I'm sorry to disturb the proceedings, my lord. I'm not supposed to be standing. However, my lord, as I have been involved in this case from the beginning, my lord, I feel the application is directed to the media. And when we had encountered some problems between the media and the court proceedings, we had a legal representative of the media who came in last year, my lord. I am asking for a short adjournment, my lord, to verify from the media if the legal representative of the media is available to come, because the application is directly affecting the media and the media needs to be legally represented before we can proceed, my lord. I feel, and I'm asking with the leave of the court, just a 5 minutes adjournment, my lord, to verify if the legal representative of the media, which we have discussed with the interaction and the bail and the conditions for the work and for the working of media in this court, I feel he has to be informed that there is an application of this sort which has been brought by the state this morning. That's my request, my lord, before we all respond to the application by the state as the court is.
Advocate Baloy, I know you have a static plan around this case. What Advocate Mshololo is beginning to say is sort of pointing us to a bit of a process to come to a ruling. I stand faced with prospects of making a ruling without infusing the Audi alteram partem rule, in the sense that it's a ruling that will have everything to do with the media, and she's saying that the media is not properly represented, in that the members of the media that are here in their capacity as journalists or whatever capacity, whereas the issue of the role of the media in this trial, I think we have discussed it a bit in the past without covering instances where there will be individual objections. My sense is that I have to listen carefully to the objection. I have to carefully consider the concerns by the witness, much as I have to hear those whom a ruling might affect. So the reason why I'm addressing you is as to whether we must, of necessity, proceed with this particular witness, given the fact that we have now recognized that there's a process that has a bit of a process that has to unfold before I make a ruling about how we shall proceed from here. And that's why I'm asking you, if I may put it in simple terms, whether there's no other witness we can be dealing with who doesn't have objections, whilst we await this other process. I'm assuming that we might be told that the representative of the media is not here. At the same time, I may be preempting a situation where maybe we will be told that the representative of the media is here, rough and ready to deal with your request.
Yes. My Lord, that is the only witness that's scheduled for today and the next couple of days. My suggestion, and I agree with Advocate Nshololo, that maybe if we adjourn for a short while, so that the issues around the objection that has been raised are threshed out, and we can then take it from there.
Anybody else?
No objection, my lord.
No objection, my lord. Thank you.